Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, ascended of Godfrey, the fifth count of Van Jews, son of folk, ruler of Jerusalem, on the reincarnation of King Edgar the Peaceful, which we know here at the Third Tipping English Church as King Edgar the Peace, or Jesus Christ, or the King of Peace. I'm here with another marvelous lecture leading off from my last lecture. And it's really very important that I do this to give everybody a better understanding of the previous information that I gave to you. All right. So without further ado, we're gonna get into it. Our focal point is going to be case law because we know law governs all things. You know, a lot of the platforms that you see in regards to claiming to be giving you the information, none of it is correlated to any type of law, anything that's going to substantiate one's right to life, liberty, and pursuit of happiness here in this present state of conditions. All right. And all that is based upon who controls the land. All right. It's all based upon who controls the land. All right. If your immediate government, in lieu of your so-called right of citizenship, does not protect your civil liberties, then you have no rights whatsoever. And there's different types of rights. You know what I'm saying? The rights that we talk about here at the Third Typical English Church is inalienable rights or God-given rights that were passed down from time immemorial, meaning a time that's unknown to your mind. Okay? A lot of us cannot go back to that time because the time that was told to us was the time that was created through the slavery story. All right. We know slaves at that time were property. They were called chattel property. All right. So without further ado, this is going to be a beautiful lesson for all those who claim to own property. All right. If you claim to own property, then that means that you have in your possession an instrument known as a certificate of sale. All right. You have what you call a certificate of sale. It's a deed to your property. It's not a deed of ownership. Once again, it's a deed to your property, not a deed of ownership. And that's a contract, all right? A contract denoting to your standing in law and a court of law, which would be that of a debtor, not the creditor, all right? It would be that of the debtor, not of the creditor. And we know a lot of the times people are assumed to be creditors when they're not. They're unsecured creditors. They're not preferred creditors because whatever they lend you is not of any equitable or substantial medium of exchange. You know what I'm saying? Because what you use to gain the property or access to the property is by way of the medium of exchange, which is nothing more than an instrument of debt. All right, an instrument of debt, whether it's a check, whether it's a banknote, those are instruments of debt. It was created for the functioning of the polity in which you now call your present day local government. All right, that keeps everything flowing. All right, so a debt instrument create debtors because you use those instruments in regards to claiming the ability to be able to access things or buy things. All right, which you have no ability to be able to purchase anything because when you purchase it, you're in a position of a debtor, all right, and you'll never be able to own anything that you purchase because what you purchase with is a debt instrument. So you don't own anything that you have in your possession, and possession means or supposed to mean ownership. Okay, so it's very important you listen to what I'm about to say or teach you today in regards to uh, ownership from a creditor and debtor perspective, a lender and borrower perspective. All right, very important. A creditor, a debtor, lender, or borrower is all based upon contract law, which is based off agreements between both parties. All right. Now, some contracts or agreements that are made based off parties, based off the positions, either debtor or creditor, lender or borrower, are unconscionable, all right, based off the original contract or agreement clause that was established for all contracts done on the state or federal level, and that will be based off Article 1, Section 10. All right, Article 1, Section 10 of the United States Constitution. All right, Very, very important to understand that clause and read it in its totality. Why? Because the majority of the things that you're subject to in regards to the position of being either a creditor, a debtor, a lender, or borrower is based upon the ex post facto laws, which put you in a position to be subject to what we call bill of attainers. All right. And as a result of that, you're subject to that status as debtor. All right. As a debtor. All right. Because everything that you do based off the position of the debtor in lieu of what we call bills of attainers through ex post facto laws that are based on what they call actions of assumption or bills of attainers. All right. If you don't act according to the contract, what happens? They haul you off in court. All right. And claim that you're the debtor because you didn't pay something. All right. You failed to do an obligation. All right. That's what we all need to recognize. And you're obligated to the contract. All right. You're obligated to the contract unless the contract is unconscionable. All right. Which means it's not on agreeable terms. We know that unconscionable contract results from what we call duress and undue influence. All right. We talked about that in my last podcast. All right. But if you haven't viewed that, I suggest you view that podcast first before you watch this one. All right. Today we're going to go into the original parties of a contract. All right. And who has a right as the original creditor to the contract because the contract is created for the benefit of the creditor. All right. I.e. the lender. All right. It's very, very important for you to understand that because majority of you don't know that the lender or the creditor is the crown. All right. And we know the crown is the monarch, and the monarch is personified by the corporation soul, which is a one natural person, which in this case happens to be me. Okay. So I'm gonna get upset about I happen to have a darker complexion. Don't get upset about I happen to know this information and you don't. It's just what it is, you know. And that proves that I am who I say I am as a result of remembering. It's not because of me learning it, it's because of me remembering it. All right. Remembering what you're supposed to learn. Remembering something that you're not supposed to learn is 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 it's for naught. Okay. So the purpose of remembering is to practice what you're remembering. And a lot of things you can choose to remember, but a lot of things you remember are not the right things. And that's what we come here today to focus on. Without further ado, let's get started. It's gonna be a good one. Sign of the TV, Sarah Seti, what's his name? Sir Ducateers, the Freedman, what's his name? Uh, Brother Lo Abba, the Canaanite Moors, the Hebrew Israelites. You know what I'm saying? All of you are over here on borrowed time because you have no proof of your right to be here on these lands. All right. Where is your proof the right to be here on these lands, or to be able to possess tangible properties on this land? All right. What gives you that right to life, liberty, and pursuit of happiness? Because that's what all these migrants are coming here for: the pursuit of life, liberty, and happiness. When you here have been here, haven't obtained that right of life, liberty yet, okay? Because it was not preserved from you from a legal and lawful perspective, all right? That's what you misunderstand. And it's going to be a great awakening. It's going to be a great demarcation between citizenship, between nationals, between standing and law. Okay? It's coming. It is coming. All right? Let's show you why. All right? We're going to break it down from a Black Laws Dictionary standpoint. From a Black Law Dictionary standpoint, but reading it from a concrete understanding or overstanding, contrast or different from how you perceive it in your present understanding. All right. So this is what I come to bring to fruition. Let's just get on to our website. This is the Third Temple English Church. Give on to our Archbishop Belmont from the House of Belmont for his illustrious job on what he's been doing, keeping it updated. All right, all the information that you would ever want to know in regards to your legal standing in law as an English man or woman is very important because as English man and woman, we have graduated from that status as men and women to lords. Very important to understand that. All right, we were created as men and women, but now we become lords. We have removed ourselves from that state of animals, monsters, beasts, back to lords because we have now entered into the house of the Lord. Okay, very, 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 very important. We are your peers. All right, no one have the right to be tried in the court of law unless they're tried by their own peers. Okay. We are nobles. United States citizenship based off the contract clause is not based off nobles. No title of nobility are to be granted. That's an unconscionable contract for English heirs and successors because we are nobles. All right. The contract clause for the Constitution for them declares that they cannot be nobles. So if you are a United States citizen or a state citizen, then you are not of our peers because we are lords. Very, very important to understand that. That's me incarnated in this present day, King Edgar the Peaceful. Look at that side view, y'all. I got my locks, but my hair ain't seeming to grow no more. I got the locks though. That's me all day long. All right. The crucifix globus, the scepter. All right. Welcome to the Third Temple English Church of England. We, as English heirs, are ordained by blood to bring the truth to the world that been living in darkness as we come forth with the law and history of our foremothers, instituted since time immemorial, written in the English Magna Charta 1215 and codified in the Statutes of Westminster 1275. Okay? Magna Charta. For sure all of you heard of the Magna Charta. It says, in the first place, we granted by God, we granted to God, and by this our present charter confirmed for us and our heirs forever that the English church shall be free, shall have her rights entire, and her liberties inviolate, and we will that it be thus observed, which is apparent from this that the freedoms of elections, which is reckoning most important and very essential to the English church, we of our period and unconstrained will did grant and did by our charter confirm and did obtain the ratification of the same from our Lord, Pope Innocent III, before the quarrel arose between us and our barons, and this we will observe, and our will is that it be observed in good faith by our heirs forever. We have also granted to all freemen of our kingdom for us and our heirs forever all the unwritten liberties to be had and held by them and their heirs of us and our heirs forever. All right? That's the Magna Charta. You can also view the other itineraries that we have here on the website. Very good, very informative. You know what I'm saying? It gives you the ability to be able to know why you're pledging allegiance back to the Third Temple English Church, i.e. the Church of England. All right? Because it proves that who house you are. You must be of my father's house. All right? You must be of my father's house. We have videos, other our itinerary as well. You know, like I said, it's a very informative website. Okay. So with that, we're going to close out on that. We're going to move on to our marvelous lesson. All right. From your king. All right. From your king. So just let's go to Black Law Dictionary real quick, okay? Everybody pull that up. The Law Dictionary. We know Black Law Dictionary was created by Henry Campbell Black in the 18th century, okay? We know in the 18th century, we know the status that we're at, all right, as chattel property, right? We understand that. We know that Frederick Douglass, he was the recorder of deeds for all properties filed within the county register, okay? And the properties that were filed within the county register were just instruments of conveyance, certificates of sale from anybody other than the original owner, okay? Very, very important to understand that. All right. He was the first recorder of deeds, but yet he was of Anglo-Saxon fraternity descent. Okay. He knew this. All right. He stated on page 58 of his book, From Bondage to Freedom. So we're on the same frequency as Frederick Douglass was in the 18th century. All right. We met him or meeting him on the ether plane. All right. How many of you are catching up to all those on that same frequency on the ether plane here in the same physical? Because we have what we call our biological memory to be able to transfer or take the body back to where the physical body, take the mind back to where the physical body cannot go. All right. This is called digital uploading or mental uploading. All right. Resonating your cellular memory. All right. Because the memory of your ancestors is embedded in your cells. All right. It's called your nuclear DNA. All right. I didn't talk about that in another class, so I'm not going to go through it for the sake of the time I have today. So we want just to define the term man from a black law dictionary, from a legal definition. All right. Not loosely, but from a legal definition. It says that a man, i.e., a human being, a person of the male sex, a male of the human species above the age of puberty, okay? Above the age of puberty. In feudal law, a vassal, a tenant, or fiduciary, okay? We know we are human beings, but then they denoted to it based off commercial aspects dealing with feudal law. And it said it is a vassal, a tenant, or fiduciary, all right? Then it states the Anglo-Saxon relation of lord and man was originally purely personal and founded on mutual contract. Okay? So we understand that if the mutual contract between lord and man, we know landlord means landlord. All right? These are the ones who receive the actual deeds of ownership. All right? In lieu of the granted right granted from the crown, i.e. the king, i.e. the monarch. Okay, so the Black Law Dictionary clearly distinguishes the difference between the Anglo-Saxon relation of lord and man, and said human being, a person of male sex, a male human species above the age of puberty. All right, so that means that you're a young adult, and in feudal law, it denotes to that of you being denoted to serfdom or slavery, a vassal, a tenant, or fiduciary. All right. So this is a person of debtor position, not that of a creditor's position. All right. Very important to understand that because you can be a creditor, but not just an unsecured creditor, contrast to the preferred creditor. All right. Because you could be working for somebody on behalf of the original creditor. All right. Let's move forward. Lordship. Everybody pull that up. Now I'm showing your status as either an heir, subject of the crown, or an alien or foreigner or a colonist. All right. I'm showing you the difference between the choices that you have to pick. All right. Based off the definition presented here from Black Law Dictionary by Henry Cameron Black. This is the second edition. So we understand the definition of man and the status of man based off commercial aspects. All right. We understand the relation of human beings or man and women in regards to the term that they use versus a lord and a man, because we know the lords were Anglo-Saxons, and we know they were consistent in the position as far as government were called the House of Lords. You had the lower house called the House of Commons, and you had the upper house, which is called the House of Lords. Okay, so when you're dealing with lordship, whole peerage as an expression, the House of Lords. All right, the House of Lords, a title of office as Lord Mayor, Lord Commissioner, etc. In feudal law, a feudal superior or proprietor, one of whom a fee or estate is held. Okay, we know there's three types of estates: fee simple, fee indefeasible, and life estates. Fee simple, fee indefeasible, and life estates. We know those are in contrast to entail estates, which are estates that are inheritable. All right, very important to understand that the difference between a lord and a man. Okay, a lord and a man. We know that the lords were the proprietors or the feudal superiors, the one who fees or estate was held, and those who worked on the land. All right, the tenant, the fiduciary, or the vassal, or the serf, or the slave. Okay, those who were subject to peonage. Very, very important for you to understand the difference. All right, that brings us to Munster. Munster, a prodigious birth, a human birth, or offspring not having the shape of mankind, which cannot be an heir to any land, albeit it be brought forth in marriage. Once again, I repeat, a monster is a prodigious birth, a human being, a human birth or offspring not having the shape of mankind, which cannot be heir to any land, albeit it be brought forth in marriage. Hold that thought. Not being brought forth by marriage. We know that when one marries, we know that birthright is based off entail or added succession, which is due paternity, not maternity, but paternity. Patrilineal sin and not matrilineal sin. All right. Very, very, very important for you to understand that. All right. So, monster is a prodigious birth, a human birth, or a offspring that having the shape of mankind, which cannot be an heir to any land, albeit it be brought forth in marriage. We understand that man is a vassal, what they said, uh, a vassal, a tenant, or fiduciary. A vassal, tenant, or fiduciary, and is different from that of an Anglo-Saxon, whose relation and legal standing was that of lordship. Okay, that of lordship. We were created in the image of the Lord. Okay, we were created in the image of our Lord. Okay, so that takes us to lords of the manor. Because lordship in England is called lords of the manor. Everybody pull that up. Historically, a lord of the manor could either be a tenant-in-chief if he held a capital manor directly from, who y'all, the crown, or a manor's lord if he was the vassal of another lord. All right. The origins of the lordship of manors arose in the Anglo-Saxon system of manorialism. All right. Following the Norman conquest, land at manorial level was recorded in the Domesday Book of 1086. The Normans' registry in Sicily was called in Latin Catalogus Baronum, compiled a few years later. The title cannot nowadays be subdivided. This has been prohibited since 1290 by the Statute of Queen Imperatrix that prevents tenants from alienating their lands to others by subinfeudation, instead requiring all tenants wishing to alienate their land to do so by substitution. Okay? So we see the origin of landlord or mannerism. All right? How the landlord or the tenant-in-chief received the right to an estate and fee. All right? Not estate and tail. Estate and fee. You got fee tail and fee simple. Very important to understand the difference. Tenancy. In England, in the Middle Ages, land was held on behalf of the English monarch or ruler by a powerful local supporter who gave protection in return. The people who had sworn homage to the lord were known as vassals. Vassals were nobles who served loyalty for the king in return for being given the use of land. After the Norman conquest of England, however, all land in England was owned by the monarch, i.e. the crown, i.e. the corporation soul, who then granted the use of it means of a transaction known as an enfeoffment. Okay? An enfeoffment is a fief. It's a land tenure given to a trustee, all right? To which are earls, barons, or others in return for military service. The person who held feudal land directly from the king was known as a tenant-in-chief, okay? Also see land tenure. So with that concept with that understanding in mind, we can move to this case law I wanted to go to. All right. Twinning versus state. Very important. Now we're going to hit a bunch of case law, but we're going to use this as our foundation. All right. United States versus Lee. United States versus Lee decided December 4th, 1882. Very important case. Everybody pull it up. Everybody there? Great. Okay. Let's set the scene. All right. The doctrine that is except where Congress has provided that the United States cannot be sued, examined, and reaffirmed. Okay. All right. So this is the sovereignty that the United States have claimed under their so-called prerogative or priority, which is by way of what we call statute. It was not original priority like that of the crown, but it was incorporated by statute. Okay? But we know that the word United States is just a term or used to cover those who make up the United States, which is their officers. Okay? Very, very important to understand that. All right? Most claims are brought forth in the name of the state or the name of the United States in reference to the officers who make up the agencies or the departments of the United States. All right? The United States is not a party in the case. All right? The United States is just represented by the officers, what would be no other than the Attorney General or the Solicitor General, which happens to be the counsel for the parties in question. Okay? For the parties in question. One is the plaintiff in error, and the other is a defendant in error. All right, and it's all based off the right of priority and prerogatives. All right. 2, that the doctrine has no application to officers and agents of the United States who, when as such holding for public use possessions of property, are sued therefore by a person claiming to be the owner thereof or entitled thereto, but the lawfulness of that possession and the right or title of the United States to the property may by the court of competent jurisdiction be the subject matter of inquiry and judged accordingly. So that means that the officers can be sued when they hold in property in their possession that actually belongs to the original owner. All right. The United States can be sued, but the officers who make up the United States can be sued in their capacity. All right. In regards to question the right of possession of property that belongs to an owner. All right. We know the United States owns property by way of what we call acquisition of sovereignty through prescription of use, easements. All right. They don't own it allodium. It's the highest form of ownership in the United States. It's fee simple, not entail. Crown land is entail. We already been through that. Those who follow along know what I'm talking about. The constitutional provisions that no person should be deprived of life, liberty, or property without due process of law, nor private property taken for public use without just compensation, relates to those rights whose protections is peculiarly within the province of the judicial branch of the government. Cases examined which show that the courts extend protection when the right of property are unlawfully invaded by public officers. Did you hear that? So you came to own something that you don't rightfully own can be brought into question by way of a writ of circulator. All right, a prerogative writ, which is called a petition of right. Okay. And ejectments, the title relied on by the defense was a certificate of sale of the demanded premises to the United States by the commissioner under the Act of Congress for the collection of direct taxes. The certificate was impeached on the grounds of the refusal of the commissioner to permit the original owner to pay the tax with interest and costs before the day of the sale. So that means that it was foreclosure on the property as a result of encumbrances not being satisfied. All right. So that means that the commissioner had put that estate up by way of a certificate of sale, which is a claim of title. It's not a clear chain of title, but it's a claim of title. All right. The certificate was impeached on the grounds of the refusal of the commissioner to permit the owner to pay the tax with interest and cost before the day of sale by an agent or any other way than by payment in person. It was held that when the commissioner had established a uniform rule that they would receive such tax from no one but the owner in person, it avoids such sale and tender is unnecessary since it would be of no avail in the first place. All right. It was re-examined, and the principles they established held to apply to the purchase as such tax by the United States as well as by private person. The facts are stated in the opinion of the court. All right. This is what Justice Miller memorandum states. There are two writs of errors to the same judgment. One prosecuted by the United States in nominee, which means that in the name of the United States, and the other by the Attorney General of the United States in the name of Frederick Kaufman and Richard P. Strong, the defendant against whom judgment was rendered in a circuit court. It was moved from the state court to the circuit court. The action was originally commenced in the circuit court for the county of Alexandria in the state of Virginia by the present defendant in error against Kaufman and Strong and a great number of others in the name of the real parties, under which the pleading to recover possession of parcel of land, which was 1,100 acres, known as Arlington State Cemetery. It was an action of ejectment in form prescribed by the statute of Virginia, under which the pleadings are in the names of the real parties, plaintiffs, and defendants. Okay? As soon as the declaration was filed in that court, the case was removed into the Circuit Court of the United States by a petition of certification, which is a writ of circular Torah and under the prerogative of the king. So when you move from a state or a district court to the appellate court, then the only way you can get remedy from a decision in the appellate court or the state circuit court or state appellate court is by a petition of certification, which under the prerogative is called a writ of circular Torah. All right, where all the subsequent proceedings took place. It was tried by a jury during the progress of the trial. An order was made at the request of the plaintiffs dismissing the suit as to all the other defendants except two defendants, Kaufman and Strong. Against each of these, a judgment was rendered for a separate parcel of land. So these are estates and land, not a lodeo land, just estates and land, which are those lands which are in controversy, namely against Kaufman for about 200 acres of it, constituting the National Cemetery and included within its walls, and against Strong for the remainder of that tract, except 17 acres in possession of Maria Synfax, which was part of what we call the Synfax family, which was the family that was brought forth by what we call slavery. You can look up the Synfax family and you can read it on your own time. Okay. As the United States was not party to the suit below, and while the defendant defending the action by its proper law officers expressly declined to submit itself as a defendant to the jurisdiction of the court, there may exist some doubt whether it had the right to prosecute the writ of error in its own name. So by virtue of the fact that the United States was not able to present himself as a party in the complaint, it rose doubt in lieu of the United States can bring a claim in their own name since you're not a party in any type of hearing or preliminary proceeding. All right. But as the judgment against Kaufman and Strong is here on their writ of error, and as under the writ, all questions are raised which can be raised under the other, their writ being prosecuted in the interest of the United States and argued here by Solicitor General. The point is immaterial and the question has not been moved, which means it's not been raised. All right. So that means there's a conflict of interest here because Solicitor General is under the Attorney General. One party is defending the plaintiff and one party is defending the defendant. Okay? Come on, man. What did that tell you? That's an unconscionable agreement by way of the unconscionable representation that the unconscionable individuals are receiving as a result of them not knowing their legal standing in law. All right? And if you're not English, then that means you don't know your legal standing in law. And you're subject to the type of due process of law that we see here, that we still see in this present day. Hold that thought. And now comes the Attorney General of the United States and suggests to the court and gives it to gives it to understand and be informed, appearing only for the purpose of this motion, that the property and controversy in this suit has been for more than 10 years and now is held, occupied, and possessed by the United States through its officers and agents charged in behalf of the government of the United States with the control of the property and who are in the actual possession thereof at the public as public property of the United States for the public uses, and the exercise of their sovereign and constitutional powers as a military station and as a national cemetery established for the burial of the deceased soldiers and sailors and known and is designated as the Arlington Cemetery, and for the use and purpose set forth in the certificate of sale, a copy which, as stated and prepared by the plaintiff, and which is the true copy thereof, is annexed hereto and filed herewith under a claim of title. So the claim of title that the United States had on behalf of the plaintiff, which happened to be George Washington Custis Lee, claimed to parts of the Solicitor General representing the commissioners by way of the property being purchased by the United States by way of what we call a certificate of sale and what we call a claim of title, contrast to the arguments brought forth by the plaintiff, which was based off a will left from his ancestors going back to General Custer Lee. All right. So it's very important. The basis of the defendant's complaint is based upon a certificate of sale, which is nothing more than an instrument of conveyance of property, a transfer of property, the sale and the purchase of property, not ownership. All right? Not ownership. All right? It says the plaintiff offered evidence establishing title in himself by a will of his grandfather, George Washington Parke Custis Lee, which divides Arlington estate to his daughter, the wife of General Robert Lee, for life and after her death to the plaintiff. All right. So if the property was transferred by way of conveyance through a will, all right, a last will and testament. All right. We know that when there's no will and no last will and testament, then that means the property automatically is streets to the state. All right, as a result of no heirs. That's called interstate. All right. All right. But we're not talking about from the subject's perspective. We're talking about it from the college perspective, how conveyances are done by way of what we call fee simple, all right, which is contrast to entail, all right. So we have to look at it from two perspectives, that of fee simple and that of entail. We're talking about entail right now. And we know that it says the United States took the property based off of a certificate of sale in lieu of conveyance as a claim of title, contrast to that which was conveyed by way of a will, by way of a last will and testament left from to an heir from a descendant. All right, but it wasn't based off the original common law way of conveyance, because we know that under common law that there was a substitution, but it was not supposed to be sold. All right, under what we call quina pentoris, which means that you cannot sell land that's through what we call substitution. All right, we talked about that in other classes. I'm not going to take time to look it up right now for the sake of time. All right. It says this with the loan possession under that title made prima facie right of recovery in the plaintiff. The title relied on by the defendant was a tax sale certificate made by the commissioners appointed under the Act of Congress of June 7, 1862, for the collection of direct taxes in the insurrectionary district within the United States, as amended by the Act of February 6, 1863. At this sale, the land was bidded in by sale commissioners for the United States, and a certificate of that fact was given by these commissioners and introduced on the trial as evidence by the defendants. If the sale was a valid sale and certificate conveyed a valid title, then the title of the plaintiff was thereby divested, i.e., it was severed, and he could not recover. All right. If the proceeding evidence by the tax sale did not transfer the title of the property to the United States, then it remained in the hands and remained in the plaintiff's possession. And so far as the question of title was concerned, his recovery was rightfully won. Okay. So either if it was based upon a certificate of sale, then that means that the plaintiff had the right of recovery. If the court ruled it based upon the will, that means that the United States had no right to divest that which rightfully belonged to the plaintiff. Okay? Here we go. We're on page 5. One, the question for the court to answer and the question for us to answer, those who are viewing this lesson, is one, could any action be maintained against the defendants for the possession of land in controversy under the circumstances of the relation of that possession to the United States, however clear the legal right to that possession might be in the plaintiff? Once again, could any action be maintained against the defendants for the possession of land in controversy under the circumstances of the relation of that possession to the United States, which is by way of certificate of sale, i.e. a claimable title, however clear the legal right to the possession might be in the plaintiff, i.e. that which was left in the will? Two, if such an action could be maintained, was that prima facie title of the plaintiff divested by the tax sale and certificate given by the commissioner? So they're telling you that if the evidence brought forth by the plaintiff wasn't separated or severed by the tax sale given by the commissioner to those who received the property by way of paying the encumbrance. All right. It is believed that no division of opinion exists among the members of this court on the proposition that the ruling of law under which the latter question did the severity of the plaintiff's right to the property in lieu of divested on behalf of the commissioner's certificate of sale, and the court ruled no. It states it is believed that no division of opinion exists among the members of this court on the proposition that the ruling of the law under which the latter question, i.e. the certificate of sale, was submitted by the court to the jury was submitted by the court to the jury was sound, and that the jury were authorized to find, as they evidently did find, that the tax certificate in the sale which is recited did not divest the plaintiff of his title to the property. All right, it did not sever the right of the last will and testament left by an heir, but that was based off being simple. Okay, because it was private property. All right, it was considered to be private property. All right, let's go Sorry about that. Everybody turn to page 13. Or go to page 106, United States, .205. Go right there. If you're looking up on just there, go to page 106, US 205. Get a marker. Come on. All right. In order to decide whether the inference is justified from what is conceded, it is necessary to ascertain if we can, on what principles the exemption of the United States from a suit by one of its citizens is founded, and what limitations surrounding this exemption in this, as in most other cases of like character, it will be found that the document is derived from the laws and practice of our English ancestors. And while it is beyond question that from the time of Edward I until now, the King of England was not suable in any court of that country except where it is consent and had been given on a petition of right. It is in a matter of great uncertainty whether prior to that time he was not suitable in his own court. It is his kingly character, as other persons were. We have the authority of Chief Baron Commons. That such was the law in Bracton and Lower Hall, that the king never was suitable of common right. It is certain, however, that after the establishment of the petitioner right, about that time as the appropriate manner of seeking relief, where the ascertainment of the parties' rights require all suits against the king, no attempt has been made to sue the king in any court except as allowed on such a petition. It is believed that this petitioner right, as it had been practiced and observed in the administration of justice in England, has been efficient in securing the rights of a suitor against the crown in all cases appropriate to judicial proceedings, as that which the law affords and legal controversies between the subject of the king amongst themselves. If the mode of proceedings to enforce it be formal and ceremonious, it is nevertheless a practical and efficient remedy for the invasions by the sovereign power of an individual right. Once again, if the mode of proceeding to enforce it be formal and ceremonious, it is nevertheless a practical and efficient remedy for the invasion by the sovereign power of an individual right. There is in this country, however, no such thing as a petition of right, as there is no such thing as a kingly head to the nation or to any of the states which compose it. You hear this? Did y'all hear this? All right. So they're telling you they know what they have done. They have separated king and parliament, which is the legislation of king and parliament, as well as the king's bench, because the king's bench is the one who decides the laws governing the king's prerogatives. We know prerogatives are the king's jure regalia. That's his priority. We're going to read it for ourselves. All right, we're going to read it for ourselves. There is in this country, however, no such thing as a petitioner right, as there is no such thing as a kingly head to the nation or to any of the states which compose it. There is invested in no other officer or body the authority to consent that the state should be sued except in the lawmaking power, which may give such consent on the terms it may choose to impose. Congress has created a court in which it has authorized suits to be brought against the United States, but has limited such suits to those arising on contract with few unimportant exceptions. Okay, let's go into these exceptions. What were the reasons which forbid that the king should be sued in his own court? And how does this reason apply to the political body corporate, which we call the United States of America? As regards to the king, one reason given by the old judges was the absurdity of the king sending a writ to himself to command the king to appear in the king's court. Did you hear that? Once again, what were the reasons which forbid that the king should be sued in his own court? And how does this reason apply to the political body corporate, which we call the United States of America? As regards to the king, one reason given by old judges, you hear that? Contrast to these new judges, because they just said wasn't no king that represented the nation here under their understanding based upon the judges who are sitting in these courts room. All right? That's what they're saying. It says as regards the king, one reason given by old judges was that, let me read it again. What were the reasons which forbid that the king should be sued in his own court? And how do these reasons apply to the political body corporate, which we call the United States of America? As regard to the king, one reason given by the old judges was that the absurdity of the king sending a writ to himself to command the king to appear in the king's court. No such reason exists in our government, as process runs in the name of the president and may be served on the attorney general, as was done in the case of Chisholm versus Georgia. nor can it be said that the dignity of the government is degraded by the appearing as a defendant in the court of its own creation, because it is constantly appearing as part of such courts and submitting its rights as against the citizens to their judgment. So they gave a case, Chittenden versus Georgia, in regards to saying that the old judges said that a court king could be summoned by way of petitioner right in his own court. That's what we just read here. All right. But they said that whoever's right in this case said it was absurd to think that these old judges would make such a decree. All right. Because in Chittenden versus Georgia, it was decreed by way of it being exerted by the Attorney General, served upon the Attorney General in the name of the President. All right. So let's go to Chittenden versus Georgia. First, let's go to Billings versus Harris. Let's see if this is it's an absurdity, all right, that they said in regards to the king petitioning the right to summon him own self in his own court. All right. Let's see how an absurdity this is. I'm gonna prove that judge wrong based off this case, Billings versus Harris. It says the state of New Jersey, whose boundaries coincide with the district, is one of the original 13 states of the Union and is a common law state. The structure of the law may be looked to for the general background about prerogative writs in general and writ of circulator in particular, which was the issue in the case we just read in what was it? 20 versus state. It says New Jersey's first constitution, adopted July 22nd, 1776, terminated its status as an English colony and began its acquisition of sovereignty existence under prescription of law as a state. Article 22 of the Constitution continues the common law of England in force. The Constitution was replaced by the Constitution of 1844, modeled largely instructed in content on the Constitution of the United States by Article 10, Paragraph 1. It too continued the force of a common law. So the 1844 Constitution of the United States was 1789 Constitution of the United States is what the 1844 Constitution of Jersey was modeled largely after. And they both was modeled after the July 2nd, 1776 Constitution. All right, as we just read. And it says, as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, continue on the force of all those existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was well vested with all power of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. This principle was especially strong in the field of prerogative writs, of which circulator was one most frequently sought. Let's see this narrated in another case. Where is that case at? Let me see where's that. Bear with me. Bear with me, y'all. Where is it at? All right, there's another case law that qualifies that. Is it national? I think I found it. National. Yeah, I found it. Hold on. All right, here we go. Okay, this is Nat Ben Franklin Fire Insurance Company versus Camden Trust Company. All right. We was reading Billing versus Harris. All right. Now we're reading the Daniel Ben Franklin Fire Insurance Company. Right. Fire Insurance Company versus Camden Trust Company. Supreme Court, New Jersey. All right. This is the Supreme Court, New Jersey. All right. It says here. The act can operate only within the framework of the Constitution. For example, the prerogative jurisdiction vested in the old Supreme Court as successor of the King's Bench by the 1844 Constitution was thus put beyond the legislative impairment. Did you hear that? The Supreme Court was the sole depository of the prerogatives of circulator, mandamus, and quo warranto. The distinguishing features of the King's Bench was that the authority which it alone exercised by means of the writs of circulator, mandamus, and quo warranto in the 1804 Constitution was framed to perpetuate in our own Supreme Court the same ample and exclusive power. Did y'all hear that? For instance, the title to the office was tribal only by writ of nature or quo warranto. That's a petitioner right. And at common law, the remedy for dissolution of a corporation by quo warranto. Did you hear that? This is what the king doing. All right? But there is no occasion to go on. It suffices to say that the declaratory judgment was designed to enlarge the early common law conception of judicial process as a means of remedying an actual violation of the personal or private rights. That ordinary, there is no occasion for invoking the measures where there is a wholly adequate remedy in the usual course of the preliminary suit for the prosecution of cause of action that has reached the stage of enforcement and such relief is sought. So let's go back to Billing versus Harris. It was long ago settled, just like they said, and that was Ben Franklin versus National Ben Franklin Fire Insurance Company versus Camden Trust Company are saying the same thing that Billing versus Harris said. Billing versus Harris from the New Jersey Supreme Court. This from the District Court. This is from the district court, all right? It said it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the king's bench, which the legislature was powerless to cut down, or assigned to other courts. This principle was especially strong in the bill prerogative of which circles was formerly most frequently sought, all right? The complexities and technicalities involving the prerogative writs, including circulator, induced the draftsman of the 1947 Constitution to erase the procedural necessities while preserving the judicial authority and the remedies. This was achieved by a single sentence. Prerogative writs are superseded in lieu thereof revealed. Hearing and relief shall be afforded to the Superior Court on the terms and the manner provided by the rule of the Supreme Court as a right except in criminal causes where shall be discretionary. So that means that you just violated the original contract agreement that this case says you was not able to impair. That's contract clause. No impairing the obligation of a contract. Okay? Let's go back to Twilling versus was it the Twilling versus State? All right. So they claim Billing versus Harris and was it national? Was it National Ben Franklin and Billing versus Harris? What they say, this case is saying totally different. All right. This case, Twilling versus State was in what year? 1908. So these are new judges. This is 1908. This is 1908. All right. I like here because I got a reference here. All right. So here they say that it's an absurdity. There is in this country, however, no such thing as petitioner right, as there is no such thing as a kingly head to the nation or to any of the states which compose it. All right. Because they removed the king. They know they did. All right, it says here. As regards to the king, one reason given by old judges was the absurdity. So they claiming that these old judges was absurd. What does absurdity mean? Let's define that. Quality of state of being ridiculous or weirdly unreasonable. Okay? So they're saying that it's unreasonable or ridiculous to think that a petition of right can be brought forth to have the king present himself before his court. We know his court is New Jersey Supreme Court, as Billing versus Harris and National National Ben Franklin's fire company said that the king bench was inside the Supreme Court of New Jersey, which the legislature was powerless to sever, i.e., deprive. All right, divest. We see it right there. So let's read some more of these case laws. This case. Page 15. That the doctrine met with doubtful reception in the early history of this court may be seen from the opinion of two of the justices in the cases of Chisholm versus Georgia. All right, where Mr. Justice Wilson, a member of the convention which framed our Constitution, after a learned examination of the laws of England and of the states and kingdoms, summed up the result by saying, we see nothing against, but much in favor of the jurisdiction of the court over the state of Georgia. A party to the cause, Mr. Chief Justice Jay also considered the question Also considered the question affected by the difference between a republican state like ours and a personal sovereign, and held that there is no reason why a state should not be sued, though doubting whether the United States will be subject to the same rule. But little weight can be given to the decision of the English court on this branch of the subject for two reasons. One, in all cases where title to property came into controversy between the crown and a subject, whether held in right of the person who was king or a representative of the nation, the petition of right presented a judicial remedy, a remedy which this court, on full examination in a case which required it, held to be practical and efficient. There has been therefore no necessity for suing the officers or servants of the king who held possession of such property when the issue could be made with the king himself as a defendant. You hear that? Two, another reason of much greater weight is founded in vast differences in the essential character of two governments as regards the source and the depositories of power. Notwithstanding the progress which has been made since the days of the Stuarts in stripping the crown of its power and prerogatives, it remains true today that the monarch is looked upon with too much reverence to be subject to the demands of the law as ordinary persons are, and the king's loving nation would be shocked at the spectacles of their queen being turned out of her pleasure, guarded by a writ of ejectment against a gardener. All right, a gardener gonna kick out the king. All right, let's just do some other case law before we continue on. United States versus Lee. United States versus Lee. In order to decide whether the interference is justified from what is conceded, it is necessary to ascertain if we can, on what principle, the exemption of the United States from a suit by one of its citizens is founded. Okay? And what limitations surrounds its exemption. And this, as in most other cases of like character, it will be found that the doctrine is derived from the law and practice of the English ancestors. Another case making reference to Edward I. And while it is beyond question that from the time of Edward I until now, the King of England was not suitable in the courts of that country except when his consent had been given on petition of right. It is a matter of great uncertainty whether prior to the time he was not suitable in his own court and his kingly character as other persons were. We have the authority. Matter of fact, if you read that, yeah, same thing as that we read in the United States versus, 20 versus state. Oh, wait, it says the king never was suitable in his own court, inserting, however, that after establishing the petition right about the time as the appropriate manner of seeking relief, where the ascertainment of the party's right required a suit against the king, no attempt has been made to sue the king in any court except as allowed on such a petition. Let's go here. Bill of exception. Ex parte claim. In England, a writ of mandamus is defined to be a command issued by the king's name from the court of the king's bench, i.e., New Jersey Supreme Court, and directed to any person, corporation, or inferior court of judicature within the king's dominion, requiring them to do some particular thing, therein specified, which appertain to their office and duty in which the court of King's Bench had previously determined, or at least supposed to be consonant to the right and justice, to right and justice. It issues to the judges of any inferior court, commanding them to do justice according to the powers of their office whenever the same is delayed. It is apparent that this definition in this description of the purposes to which is applicable by the court of the King's Bench as supervising the conduct of inferior tribunals extends to the cases of refusal by an inferior court to sign a bill of exception, where it is an act which appertains to their office and duty, and which the court of King's Bench supposes to be constant to the right of justice. A bill of exception is what you do in what we call an appeal. It's just like an appeal. Let me just give you an example. Everybody see that? You see that date? January 30th. All right. 2974. This is the docket number for the Third Circuit Court. King Clifford Jefferson petitioner, City of New Brunswick, appeal, bill of exception. All right. All right. This is a bill of exception that I done in regards to a fee waiver that was denied by the district court. All right. And the same reason I gave to the district court, which was denied, I gave to the Third Circuit Court of the appeal, and they granted the fee waiver. All right. And the appeal is about denial of the fee waiver. Let's read a little bit of it. All right. All right. Now, I was granted the fee waiver to file an appeal about the denial of an IFP application that was denied by a district court judge. All right. And this is the verbiage that I used in the application and the motion for acceptance of the IFP application for my right to appeal the district court denial of my IFP application. All right. So this is the verbiage I use. It says, appeal bill of exception argument. Judge Georgette Castro cut and paste order are biased because it's defective without a memorandum justifying the pleading's deficiency. But does show an attempt to deny petitioner's right to redress in a court of law on account of safeguarding the legalization of paper currency as a substitute for what the Constitution of Article 1, Section 10, and United States Code 31, United States Code Section 5, 5115 asserts. The order stated, that the applicant shall have 30 days to pay the filing fee or file an amended complaint that complies with those pleading standards. On January 11, 2024, an order granting IFP application was filed with the district court on behalf of the petitioner, where the clerk was ordered to file the complaint, but no summons was issued pending the court screening of said filed complaint. If this is the procedural process for which the IFP and complaint is processed in the district court, then how was Judge Georgette Castro able to review a complaint that was not filed with the court until after the IFP was decided? King Clifford Jefferson, Trenton Municipal Court. This is the one she ruled in favor of my IFP application and granted it, and the complaint was not even filed yet, because you can't file a complaint until the IFP application, the motion to grant the IFP application is decided. Okay? The Supreme Court has power to issue mandamus. I'm not going to go into that, but it just shows you what a bill of exceptions look like. Okay? That's what it looks like. Yeah, we nice here at the Third English Church. We nice from His Majesty. was the fee waiver, the IP application. Let me just show you that real quick, since we're here. Okay. Everybody see it? And of course, it was granted. Okay, this is the verbiage I use. Motion for leave. Motion for leave to proceed in formal appropriates. All right. Petitioner asks for leave to file a tax petition for writ of circular without prepayment of costs and to proceed in formal appropriates. Petitioner was allowed to proceed in the United States District Court in the matter of Trenton versus Blase Blase. You just read that. All right. Article 6 of the United States Constitution establishes the law and treaties of the United States made in accordance with it as the supreme law of the land forbids a religious test as requirement for holding any government position and holds the United States under the Constitution responsible for the debt secured by the United States under the Articles of Confederation. I use the Currency Act of 1751, restricted the issue of paper money for payment of debts. Article 1, Section 10, a gold and silver should be paying for all debts. Article 6, 9, and 10 of the Jay Treaty. The United States should make full, complete compensation for the same to said creditors. You hear that? Such insolvency of the debtors or other causes or will be equally have operated to produce such loss if the said impediments had not existed nor such losses or damages to claimant. Article of Confederation resolves 1 through 10 identify the city and the state of your legal resident parts of Articles of Confederation resolves 1 through 10 identify the city and state of your local residence. There is no city or state. The legislature of New Jersey amended the Constitution September 20, 1777 by substituting the word state for colonies to colonies. New Jersey Constitution, July 7, 1776. So as a result of that, what was I going to go to? Where was it? Where is that? It said the United States was a creditor. Where is that at? Oh, yeah, right. The United States will make full and complete compensation for the same to the said creditors. We know the United States are not creditors. The United States are debtors. All right. Once again, the United States are not creditors. The United States are debtors. Okay. So let's go here. Now, it said in Twining versus State that the Stuarts stripped the authority on the prerogatives of the crown. It said that the Stuarts stripped the prerogatives of the crown, so they never really represented the crown, the English crown. They only represented their crown. All right. This is from the Second Circuit Court. All right. My appeal of bill of acceptance to the Third Circuit Court, using what Marshall versus New York says in the Second Circuit Court. All right. And what does it say? At common law, the Crown of Great Britain, by virtue of a prerogative right, has priority over all subjects for payment out of debts, property over all debts due to it, whether the property was in possession of the debtor or a third person or in custodial legis, and the priority could be defeated or postponed only through the passing of the title to such property, absolutely by way of a lien, before the sovereign sought to enforce his right. Let's find some other clues to this. Aetna versus Casualty Company. Aetna versus Casualty Company. You're right here. Aetna Casualty Company and Surety, Aetna Casualty and Surety Company versus Bromwell. All right. I have Aetna right now as my primary medical coverage. And now I'm reading this in regards to the positions of creditor and debtor. All right. They claim to be the lender and I'm the borrower from them. Now I read this. This is what it says. This kingly power or authority or privileges, whatsoever its scope or whatsoever attribute there is in it of sovereignty, rests with the people of this country. They may volatilize. Yeah, they may volatilize it into. Let me go a little further. Right here. It is hardly essential to define prerogative with technical accuracy. Under William Mr. Blackstone's definition, it can only be applied to those rights and capacities which the king enjoys alone, in contradiction to others, and to those which he